Tell me when you're ready and I'll go.
You good?
Go ahead.
Good morning, everybody, and welcome to this Friday panel discussion. I hope everybody's doing well. Just a couple announcements. My name is Paul Miller. I am on the board of directors for the National Institute for Lobbying and Ethics. I'm going to turn it over to our president, Tommy Goodwin, in a second. But want to make an announcement. Please go to our website, www.lobbyinginstitute.com, and you will be able to find the programming we have for the rest of the year. We have some outstanding programs coming up, and the next one on tap is Monday, July 13th from 10 a.m. to 11 a.m. And the focus will be on today's lobbying profession and the need for diversity. So we have a very good panel of folks that we're going to spend that hour talking about diversity in our profession and what we can do a little bit better in that way. I also want to let you know, for those of you who need CEU credits, we do allow for that. So we do have the form. If you need to do that, please let us know and we'll send you that form so that you can fill that out and get that back to your employer. And as for those of you who are part of our public policy certificate program, we are allowing you to take this program as credit towards that. So let us know if you do need that. So the only last thing I would like to just say is the pandemic has hit every industry, every profession around the country, obviously with getting close to 50 million unemployed people in this country. And that has meant a lot of our own folks have been displaced from their job or furloughed. If you are having problems or you're one of those folks who need some help, please let us know how we can help you in any way. We do have a job bank. We are talking to folks about how we can do things from job webinars and things like that. So please let us know how we can be of help to you. With that, I'm going to turn it over to you, to Tommy, to take it over from here. But I appreciate everybody being here, especially the panelists.
Thanks, Paul. As Paul mentioned, I'm Tommy Goodwin. I'm the volunteer president for NILE, and on behalf of the entire board of directors, some of whom are with us here today, I want to welcome you to today's session on the intersection of the Paycheck Protection Program and our lobbying and advocacy world. For those of you who are new to NILE or haven't been with us as part of these sessions over the last few weeks, today's conversation is part of a series that Paul and Nicole Smith have put together on the impact of COVID-19 on our profession. A couple of weeks ago, J.B. Bird and Rob Burton joined us to share their thoughts about how getting messages out has changed in COVID-19. And just earlier this week, we had an all-star panel of congressional staff and lobbyists who gave us their firsthand point of view of how Capitol Hill is adapting to this new world. And as Paul said, we've got quite the lineup of events that are going to be taking place over the next couple months. And we'll talk to you about how we get you signed up for those at the end of today's conversation. So with that, let's bring in our esteemed panelists and kick off today's discussion. I think as everybody knows, over the last few months, Congress and the administration have adopted some pretty unprecedented policy responses in response to the fallout of COVID-19. And I think it's probably also fair to say that the most significant and really at times probably the most controversial of those programs is the Paycheck Protection Program, or as we all know it, the PPP. Administered by the Small Business Administration, we all know that the PPP is a forgivable loan program that's designed to provide incentives for small businesses to keep their workers on the payroll. And while this program has been successful, I think more than 4 million small businesses nationwide have received PPP funding at this point, and a few big businesses and others maybe who shouldn't have received it as well. Both the statute and I think we're up to 19 interim rules now that are governing the program have left some folks out in the cold on this one, and that includes organizations that are directly impacted by our profession. So whether that's political consulting and lobbying firms, nearly all of which meet the SBA's definition for small business, or not-for-profit associations who, among other things, do petition the government for the redress of grievances on behalf of their members. These folks have been excluded from the PPP, and as we sit here today, I think it's very much up in the air as to whether these organizations and others will be granted access going forward as Congress considers its next COVID-19 response package. Now, I wish I could say this is the first time that policymakers have turned a cold shoulder to our profession and that we were the only profession that finds itself in the headlines from time to time that gets treated this way, but that's not the case. And that's really why we have 4 folks with us today who have been and are at the forefront of these ongoing conversations and battles, who are here to share their stories, their perspective, and their advice for those of us who are part of the lobbying profession today. So with that, I'm going to kick this off by asking each of our panelists maybe to talk for a few minutes about their experiences around our topic here today, and then we'd like to throw it open to all of you for questions and answers. And we really do want this discussion to be an actual discussion. So please submit your questions using the Q&A feature that you'll find at the bottom of your screen. And we're going to get to all of those during our time together today. And just one last thing before we get started, to make sure that we can have a full and robust conversation, I just want to remind everybody that Nile operates these sessions under the old Chatham House rules, or the Las Vegas rules. And that means that everything here that we're going to talk about today is 100% off the record. It's not for attribution, publication. Please don't tweet things out with things attributable to folks who are speaking here today. We really want to make sure that we're able to have a robust conversation, and that helps us do that. So let me begin. Let me bring in Charles Rothfeld, who is with the Mayer Brown Law Firm. Let me introduce Charles. He was recognized by the National Law Journal as one of the leading members of the Supreme Court Bar, and by USA Today as one of an elite private sector group of lawyers who dominate advocacy at the Supreme Court. That's quite the line. And focuses his practice on Supreme Court and appellate litigation. His experience has gotten him repeated listings in Chambers USA, which noted his description by clients as a genius, and for his work on a vast number of Supreme Court appeals. And this has also gotten him recognition in Best Lawyers in America and characterization of one of Washington's top lawyers by Washingtonian Magazine. He's worked more than 200 cases before the United States Supreme Court and on hundreds of other cases before federal and state appellate courts. Charles is with us today because a few years back, he represented a group of lobbyists who sued the Obama administration over a 2010 policy that kept registered lobbyists from serving on some federal advisory boards. So Charles, thank you very much for being with us today, and let me turn things over to you for a moment.
Great. Well, Tommy, thank you for that gracious introduction, and thanks to Niall for inviting me to participate in talking about a very interesting and important topic. And to some extent, the fact that we are here is proof that nothing ever changes in Washington, because, as Tommy mentioned, my involvement in this issue involved a rule that in some respects is very similar to what brings us to talk about the PPP program today. As Tommy mentioned, I brought a suit on behalf of a number of lobbyists challenging the Obama administration rule that barred registered lobbyists from serving on government advisory committees. And as I'm sure most of you know, there are many such committees that operate kind of in policy areas all across the government. The Obama administration policy barred all registered lobbyists from serving on all advisory committees. And the ostensible purpose of this program was to eliminate or reduce insider influence in the formulation of policy and expand access for ordinary Americans. In my case, which ultimately became known as OTERV, which is the name of one of the plaintiffs versus Pritzker, who at the end of the case was Secretary of Commerce, challenged the constitutionality of this limitation. And it was brought on behalf of a number of registered lobbyists who were barred from serving on a particular type of advisory committee called an ITAC, an Industry Trade Advisory Committee, which was created to provide a mechanism for industries to, specifically to address their issues, their concerns with international agreements that bore on their businesses. So they were an advisory committee that operated under the auspices of the U.S. Trade Representative and Secretary of Commerce. And nevertheless, the Obama administration policy kind of barred all registered lobbyists from being selected by their industry to serve on the ITAC in their area. And we challenged this rule under the First Amendment in a suit that we brought in federal court in the District of Columbia. And we thought that our argument was very simple and powerful. Lobbying, as Tommy's introduction mentioned, is petitioning the government. It is protected under the First Amendment. It should be protected every bit as much as other areas of activity that are protected by the First Amendment, like speech or like the exercise of religion. And therefore, our view was that discriminating against people because they exercise their First Amendment rights is inconsistent with the Constitution. And we invoked a principle that's known as the unconstitutional conditions doctrine. That says that government is not obligated to create benefits, create programs for people, but that if it does, it can't bar participation in a manner that infringes on constitutional rights. It can't condition your receipt of the benefit or your participation in the program on your surrender of a constitutional right, like your right to speech or your right to petition the government. That doctrine initially was applied to government employment in a circumstance where, for example, the state was held that it could not exclude people from teaching because they were members of the Communist Party, or the mayor of a city couldn't refuse to hire someone as a police officer because they didn't join the mayor's political party. But it's been expanded to address all kinds of government programs and benefits, even things that are as ephemeral as participation in an Adopt a Highway program. And we thought that certainly should apply to participation in an ITAC. So we thought that it applied very straightforwardly to our situation. And in some ways, the most interesting thing about our case is that not everybody saw it that way. When we brought the suit in district court, the judge who heard the case at the trial level, Judge Amy Berman Jackson, who's now sort of most well known for the sentence in Roderstone, she thought that our argument was almost frivolous and kind of dismissed it out of hand. She didn't see any First Amendment right involved, and that participation in the government committee is not really the kind of benefit that would trigger unconstitutional conditions doctrine anyway. And when we appealed that decision to the D.C. Circuit Court of Appeals, the government treated the argument as though it were borderline frivolous. They filed a 20-page brief for the D.C. Circuit, and for those of you who practice, a 20-page brief is shockingly short to defend a challenge to a significant government program. But the story has a happy ending. When we got to the D.C. Circuit, we had an ideologically balanced panel, one Reagan appointee, a Carter appointee, and a Clinton appointee. And they found the case compelling, and they reversed the district court decision. They ruled for us. They said clearly lobbying is protected First Amendment activity, that participation in government committees is a benefit of the sort that triggers the unconstitutional conditions doctrine. And I have to say, I have never seen a government lawyer as thoroughly eviscerated in an argument as the lawyer who defended the Obama lobbying ban. I mean, they're basically, the judges sort of pummeled him, and I thought it was very gratifying for me, but extremely painful for him. And technically, the panel sent the case back down to the judge to consider other arguments that the government might advance, but the government saw that their position was hopeless after the treatment in the D.C. Circuit, and they kind of threw in the towel and rescinded the rule as applied to ITACs. And just conclude very briefly, I sort of drew two conflicting lessons out of this that are relevant here. One is, the right to petition and sort of the treatment of lobbyists who do that is to some extent viewed by courts as sort of the poor stepchild of the First Amendment, and sometimes gets taken less seriously than it should be, which I think explains what happened to us in the district court. But the other contrasting lesson is that, in fact, the First Amendment does protect lobbyists, and the D.C. Circuit saw that very clearly and issued a pretty clear ruling, striking blue for that principle. And so with that, I'll turn it back to you, Tommy.
Thank you, Charles. It's very interesting perspective and experience there. Let me now go ahead and bring in our second panelist, Dave Summers from the Project Management Institute. Dave is the head of global government relations for Project Management Institute, or PMI, which is the world's leading not-for-profit professional membership association for the project management profession. He leads a dynamic government affairs office that focuses on bridging effective relationships and strategic alliances between PMI and various stakeholders within Congress and the administration, as well as working north of the border with stakeholders in Canadian ministries and Parliament. Also collaborates with PMI's portfolio of government relations team around the world, which includes the UK, the European Union, and other locations all around the world. Prior to joining PMI, he spent nearly 20 years launching and leading high-profile projects, innovating at the intersection of politics and technology, and building deep relationships with clients, partners, and communities. He's held leadership roles within Koch's nonprofit network, worked with corporate association PACs while at Aristotle, and ran statewide and federal political campaigns in Wisconsin. Dave is with us today because PMI is a professional association that is incorporated under Internal Revenue Code Section 501c6, which makes PMI one of more than 62,000 associations across the country that have been denied access to the Paycheck Protection Program, ostensibly because associations are engaged in lobbying that advances their members' interests before Congress and the administration. So with that, Dave, let me bring you in. Welcome, and the floor is yours.
Tommy, thank you for the kind introduction, and thanks to the Institute for having me today. As Tommy said, I'm here representing the Project Management Institute, which is the world's leading not-for-profit association for folks who consider project, program, or portfolio management their profession. Just to share a little bit about PMI, we've got nearly 500,000 members in the US, over 1 million certification holders around the world. And then when you take a look at members, certification holders, volunteers, anyone connected to PMI, we've got a global footprint of around 3 million people. So true reach for an association. So what do? We work to further mature the project management profession through globally recognized standards, through certifications, through communities of practice, through resources, a lot of publications, tools, research, professional development, and networking opportunities. So truly Batman's utility belt for those project managers out there. We help our members advance their careers, but we also enable their employers to improve organizational success and achieve outcomes. Now, as a part of our mission, we work to improve project and program performance within the US federal government, state government, and governments around the globe. And so to further that mission, we've got 2 lobbyists on staff presently. Now, lobbying governments is a small part of what we do at PMI, but we think it's a very important part to make sure that folks across the country and truly around the world get value for tax dollars that are invested in government projects and programs. So that's a little bit more about PMI, but to speak to the association community overall across the country, there are tens of thousands of not-for-profit associations very similar to PMI that are major drivers of the economy, but also work every day to advance important societal goals. And just to expand a little bit on the numbers that Tommy shared, there's over 62,000 501c6 associations, and we employ over 205,000 Americans. And that's a payroll across all 501c6s, around $18 billion. But why that number is important is around just under 4 billion would be eligible for PPP funding if every association were to be included, which, considering that depending on who you talk to, there's between 100 and 130 billion dollars left. It's a drop in the bucket. It's not an impactful number. So what is impactful, though, is what these associations are feeling as a result of the COVID-19 crisis. The associations are hurting. ASAE, which is the American Society of Association Executives, found that 63% of associations will lose up to half their revenue this year due to event cancellations, decreased spending on memberships, certifications, or other revenue, and that 43% of those associations will spend up to half their reserves to make up that gap. But sadly, around 5% of associations won't have enough reserves to cover those losses. So that means 1 in every 20 not-for-profit association in America could go out of business this year. And that's terrifying. That's why what we're doing is so important. And with that, I'll give it back to Tommy.
Wow, those are some pretty drastic numbers. Thank you very much for sharing PMI and the association community's perspective. Next up, we're going to bring in Steve Roberts from the law firm of Holtzman, Vogel, Josfak, and Torchinsky. Steve is a partner at the firm who is focused on lobbying compliance, campaign finance, and political action committees. As part of this practice, he advises his clients on compliance strategies with federal, state, and local lobbying laws, pay-to-play limitations, campaign finance restrictions and requirements, and gifts and entertainment limitations for government officials. He is also a subject matter expert on a host of issues that are highly pertinent to corporations and organizations engaged in grassroots lobbying and political engagement and advocacy. And as a former registered lobbyist himself, he works diligently to guide his clients to political strategies that are both compliant and effective. So that's a wonderful combination of skills to bring to the table. Steve is with us today because he recently represented the American Association of Political Consultants in a lawsuit against the Small Business Administration as part of their effort to seek access to the PPP for their member firms. So Steve, thank you very much for being with us today, and please take it away.
Thanks very much, Tommy, and thank you and Niall for allowing me to spend a little time with you all today. On behalf of our client, American Association of Political Consultants, and one of its member firms, we sued the Small Business Administration of DC Federal Court. And our arguments there were essentially that the PPP loan program, as established by the CARES Act, was administered in an unconstitutional manner, given the reliance on SBA's existing ineligibility regulations in determining what types of businesses would be not permitted to be granted a PPP loan. Those ineligibility regulations prohibit certain businesses from receiving any SBA business loans, the 7A loans that we were more familiar with prior to PPP, including businesses primarily engaged in political or lobbying activities. Now, those terms, political and lobbying activities, are undefined in the regs, and that's an important point that I want to come back to just a little bit later. But in this case, specifically, we argued that the administration of the program was unconstitutional in the following three ways. One, it creates a content-based speech ban, since it requires an enforcement authority to examine the content of the message, what the speaker is doing with the speech that's conveyed to determine whether a violation occurred in the first place. Two, the way the PPP loan program was administered was that it created an unconstitutional condition on speech by granting a government benefit on the explicit condition that a speaker abandon her right to free speech and association in order to receive that benefit. And three, it was unconstitutional by excluding businesses primarily engaged in political speech or lobbying activities by depriving them of equal protection in violation of the Fifth Amendment, because other similarly situated businesses not excluded by SBA eligibility rules would be eligible for the loans. And that's made even more important because political speech and lobbying activity is core protected First Amendment speech. Unfortunately, in the DC district decision in this case, the court sided with the SBA in finding that PPP loans were actually subsidies for businesses, for business activity rather than loans. As you're familiar with, while they're forgivable loans, they're forgivable only under very specific conditions detailed in those rules, interim rules for the PPP program. Therefore, I mean, we think it's certainly an error that the court found that they were a subsidy. So we appealed it. We appealed it to the DC Circuit, and we focused on that argument that the PPP loans are not a subsidy over 12 pages of our brief. And unfortunately, the Circuit Court still agreed with the lower court in a per curiam opinion, sort of brushing aside that 12-page argument as tenuous. A little frustrating. I'll let Brad speak to his arguments on statutory language that were ultimately successful in other districts, but I do want to spend a minute discussing two other important considerations for lobbying or political firms that are interested in PPP loans or receive PPP loans. First, on the application form itself for the loan, an applicant is required to make a number of certifications in good faith regarding the business and its eligibility for the loan. Among those is that, and I'll quote here, current economic uncertainty makes this loan request necessary to support the ongoing operations of the applicant. That's the certification. Let's face it, these are pretty good times generally for lobbying and political firms. The uncertainty in government along with fast-moving legislation means that a lot of our clients have had stacks of new client signups. They've had increased business from existing clients. So we've had lobbying firms and other clients decide not to go forward with the application for a PPP loan after they looked at that certification and decided they couldn't really say that it was absolutely necessary. Second, as we discussed, the language of the ineligibility rule prevents loans from going to those businesses which are, quote, primarily engaged in political or lobbying activities. And historically, throughout the US Code, primarily means over 50%. So the definitions of the terms political and lobbying become really important to determine whether the ineligibility rule even touches your business. So for instance, say you're a firm that's registered to lobby at the federal level for a handful of clients, but you also have a handful of other clients for whom you advise on federal government procurement, for instance. For that second bucket of clients, you don't trigger lobbying registration because you don't engage in direct lobbying. And let's say that makes up 60% of your annual revenue. You're probably not ineligible for the PPP loans, but There's no clarity from the SBA on that point. Similarly, what if you're registered to lobby at the federal level for all of your clients, but not all of your work for all of your clients is reportable as lobbying activity? There, it's probably worth taking a careful calculation of the percentage of revenue or time you're spending on lobbying versus non-lobbying to determine whether you'd be eligible even if these rules still apply. And then another uncertainty, what's the applicable definition of political or lobbying activities? So as you probably know, lobbying is defined very differently under the tax code versus the Lobbying Disclosure Act. And that's to say nothing of the varying definitions at the state and local levels. So depending on what definition you choose to use can affect your eligibility tremendously. So for instance, say your firm focuses 100% on grassroots lobbying for clients. At the federal level, if you choose to use the tax code definition of lobbying, which sweeps in grassroots activity in an effort to lobby legislation, you're very likely disqualified from an SBA loan under the eligibility rules, which may or may not still apply. However, if you use the LDA definition of lobbying, which regulates only direct lobbying contacts in support and activity in support of those contacts, then none of your activity is lobbying, so your firm would be eligible for an SBA loan. And again, the SBA has provided no clarity on this point, either before the PPP, when this applied to 7A loans, or now. I'd also add that in some off-the-record discussions we've had with the SBA on the application of the ineligibility rules, we've got no guidance or clues as to the position of the agency as to how they treat this. So since you only have until Monday to apply for a PPP loan, I'd suggest you very quickly get out your abacus and do some calculating as to whether you might be eligible. And thank you.
Steve, thank you very much for that overview and that very sage advice for all of us here today. Finally, let me go ahead and bring in Brad Schaefer from the law offices of Schaefer & Associates. Before I do, I would like to remind you all to submit your questions for our panelists using the Q&A feature at the bottom of the screen, and we will begin to get to those here in just a few moments. Back to Brad. He practices primarily in the areas of constitutional law, labor law, business and corporate litigation, personal injury defense, and appellate practice. The primary area of concentration in his constitutional law practice is that of First Amendment litigation, so free speech, expression, association rights, and the like. His practice in First Amendment law has included acting as counsel for 3 of the parties before the United States Supreme Court in the case of Barnes versus Glenn Theater, and has also been involved in free speech rights of those exercising their Second Amendment rights to keep and bear arms. As I mentioned during the introduction today, lobbying is far and away not the only field that has been impacted by some of the PPP rules and regulations. And recently, he successfully represented a group of adult nightclubs in their efforts to gain access to the PPP, despite SBA rules stating that businesses that present live performances or sell products of a prurient sexual nature were excluded from accessing the program. He is also representing another group of adult nightclubs over denial of EIDL applications under the PPP, and a paycheck cashing company that was denied a PPP loan, and also an emergency room physician placement company where the SBA is seeking a refund of their PPP loan. So Brad has quite a bit of experience with this fairly nascent program and is going to be batting cleanup here for us today. So Brad, thank you very much for being with us, and the floor is yours.
Thanks. Thanks for having me. I appreciate it. The other lawyers have pretty well teed up the constitutional issues that we raised, and I really came to this case because I am by trade a First Amendment lawyer. I'm past president of the First Amendment Lawyers Association. I've practiced all over the country First Amendment law for decades. I've been a First Amendment lawyer from not only the very first day I was licensed as an attorney, but 2 years as a law clerk. And so when we saw on Thursday evening, the evening before the applications for the PPPs came out, the interim final rule, which is an oxymoron in and of itself, that engrafted the exclusive or the excludatory provisions of the regular Section 7A loans, and that regulation is generally referred to as 120.110. We immediately dropped everything we were doing and within a week got a lawsuit ready to file. I was really champing at the bit because this is very juicy First Amendment work. Steve and I actually had a conversation early on in our various lawsuits, and I told him that I was actually in an enviable position, because normally if I'm representing, for example, an adult business, I go into court and the judges are always saying, and the opponents are always saying, well, this isn't core political speech. This isn't, you know, the things that people go off to war to protect. Whereas here, because of the way that the First Amendment distinguishes between content-specific laws and what are called viewpoint-specific laws, we, the adult nightclub industry in our case, actually, I thought, had a much better First Amendment argument than Steve did, because it isn't like just democratic lobbyists were being precluded. There wasn't viewpoint discrimination in the lobbying preclusion, but there was with regard to the prurient sexual nature. There wasn't just a ban of entertainment. There wasn't just a ban of live entertainment. There was only a ban of live entertainment, or entertainment that was of a prurient sexual nature, whatever that meant. And so we did exhaustive briefing with regard to the constitutional issues, but we also raised what turned out to be the key issue in our case, which is what we lawyers generally refer to as a Chevron argument, which it comes from a US Supreme Court case. Basically what it says is that if Congress has spoken unambiguously, the administrative agencies have to follow that, and they can't go on their own and make things up. And so what I did was we filed our lawsuit, and then a friend of mine in Wisconsin wanted my pleadings because he wanted to file his own case. I gave him my pleadings, he filed, and we kind of had competing lawsuits. And what happened in his case is his judge ruled on the Chevron argument as well as the constitutional arguments. My judge, because of a doctrine called the doctrine of constitutional avoidance, you shouldn't rule on a constitutional issue if you can make a decision based on some other grounds. And that's what my judge, Judge Lightman from the Eastern District of Michigan, did. In a 45-page opinion, what he found is not just the prurient sexual nature or regulation was invalid, but the entirety of section 120.110, which, by the way, includes the lobbying preclusion as well, that was invalid because Congress never intended that there were going to be these type of exclusions. In fact, the legislative history showed that the PPP and the CARES Act was meant to expand coverage for people to get emergency relief out of the CARES Act. And one of the ways we spun this to the judge was we kept harping on the difference between a PPP loan and a regular Section 7A loan. A PPP loan can only be used for 4 purposes: payroll costs, rent, mortgage interest, and utility bills. And what we kept saying is our employees have their own bills they have to pay. We're trying to keep commerce going here during this pandemic. Our landlords aren't engaged in entertainment of a prurient sexual nature. Of course, we alleged our clients were not engaged in entertainment of a prurient sexual nature because the government could never define what that was, and in fact, changed their position 3 times during the litigation. That mortgage holders were not engaged in that, and utility companies shouldn't be punished for the utility bills that our clients would have to pay because of the engrafting of this regulation. And our judge, in fact, fully agreed with that and ruled that the entire importation by the SBA of all those exclusions in 120.110 was invalid. Now, there's a second component of Chevron that is generally referred to as a Schurz standard, comes from a case from the Seventh Circuit U.S. Court of Appeals. And what Schurz says is that if an administrative agency is going to act, you have to take a look at whether a reasonable person would believe that what the agency did was a reasonable response to a problem that Congress had delegated to the agency to solve. And so in our briefing, we raised this issue. Now, interestingly, my friend in Wisconsin, while he took my original briefing, he went on in his reply briefing and things like that, did his own thing. He never raised the Schurz argument, but we knew our judges and Steve's judge, while I don't know if they were communicating, they were certainly all cyber squatting each other's cases. And I know that for a fact because that came up numerous times in we had 4 different preliminary injunction hearings on our case. And so we raised the Schurz argument, and lo and behold, while our judge never had to get to that, Judge Edelman in the Wisconsin case did cite to Schurz and said, determining who is supposed to be getting loans and shouldn't be getting loans, that isn't an issue that Congress delegated to the SBA. The SBA had only 2 criteria, and this is what our judge said. You have to be in business during the covered period. You have to have fewer than 500 employees. And so that's what he ruled. Now, the reason that my ruling doesn't help you guys out directly right now is because our judge was very clear that his order was not a national injunction and only applied to the plaintiffs in the case. So really, he limited himself to the prurient sexual nature exclusion, not all of 120.110. And with that, I'll turn it back to you, Tommy.
Brad, thank you very much for that. So for everyone here with us, we've heard from our all-star panelists, and now we'd like to hear from all of you. For those of you who have submitted questions already, thank you very much. We appreciate those, and we have all those queued up and ready to go. For everyone who has not submitted questions yet, or if you have more questions, please keep them coming by entering them in the Q&A feature down at the bottom of the screen. To get started, Brad, since we most recently heard from you, I want to keep you up here on screen for a moment or two here with questions. Sure. You talked about this a little bit, but first off, what applicability, given that it was sort of a local injunction and it was very narrow, does that decision have any, and the Wisconsin decision as well, does it have applicability beyond the adult nightclub industry from your perspective?
Certainly, given the language of our court's order, it does, because Judge Lightman's decision is not limited to only finding the prurient sexual nature provision unconstitutional, an issue he never addressed. What he found is that the SBA simply exceeded its authority to pull all of those exclusions from the regular Section 7A loans, which can be used for everything, unlike the PPP loans that can be only used for a limited nature. And so that would arguably apply to lobbyists, 501c3s, and the myriad of other things. Oh, and one of the other things I forgot to mention was in the midst of our litigation, and literally the night before one of our hearings, the SBA came out with a new guidance that said small casinos could now qualify for PPP loans. And the reason is that was the intent of Congress to expand the scope of people who would be entitled to these emergency funds. And the judge said, well, that kind of shows the whole idea of Congress. If they're acknowledging that, that follows exactly what Congress was doing. And so this importation of all these other exclusions was simply invalid.
That's very interesting. And I guess, and you may not know the answer to this question, but in follow-up to the decision, have the clients that you represented actually been able to get banks to approve those PPP loans irrespective of the regulations that exclude all the businesses that you've outlined earlier?
Yes, that was part of our preliminary injunction. We had you have to understand that these are not SBA loans, unlike the EIDLs, which is my second lawsuit. That money comes directly from the SBA. The SBA gives guarantee authority. And so our judge ordered set aside guarantee authority and then ordered that these loans be granted. We never sued any banks. And there's a whole host of reasons that we didn't do that I don't want to get into here. But the order clearly said you can't use this regulation in order to exclude. So they were all able to get it. Now, the interesting thing, both in my case and the Wisconsin case, and this has developed only over the last couple of days, because both decisions were appealed up to the various appellate courts, and the SBA requested stays. The stays were denied in both cases, but over the last couple of days, the SBA, kind of with some pushing from my judge, the SBA has agreed to stay not only the district court cases, but the circuit court of appeal cases as well, to see if there are going to be any problems in the forgiveness phase. And assuming there's no problem in the forgiveness phase, and this is all over and done with, these cases may just die on the vine.
Interesting. Okay. Thank you very much for that, Brad. Steve, let me bring you back in here for a question or two. And given Brad's experience, it appears as though certain exemptions are being granted either by SBA or the courts to allow access, but not others. And, Brad mentioned small casinos. We know there's also been some rulings that have allowed churches to receive PPP loans. I'd just be curious your take on why you think the SBA has supported those particular industries or those particular professions, but not necessarily those of the political consultants and the like.
Yeah, and I think there are probably two reasons there, two practical reasons. One, politically, it's a lot easier to get behind groups of churches rather than groups of lobbyists and political consultants, unfortunately for the industry that we all work in. So I believe that from a practical standpoint, politically untenable to continue to exclude churches from eligibility for the loans. And then as well, a case out of New Mexico found that churches were eligible for loans. A group of churches that were bankrupt sued the SBA out there, again, using an APA argument that was very similar to Brad's successful argument, totally sidestepping these constitutional questions so that courts didn't have to go down the road of determining whether the PPP loans were in fact subsidies, which would sort of take away some of those constitutional protections that we believe would apply.
Interesting. And I guess within that context, talk to me a little bit about your response to the court's decision in the AAPC case that, opposed your argument on the Equal Protections Clause. And also, there's a bit from the chat here that I was curious about, which is, given sort of the discrimination arguments that you outlined, people are being discriminated against for practicing a certain type of speech, it's curious, why hasn't that been in play with the courts? Why is this particular profession being discriminated based on what it does versus others that aren't really subjected to that kind of argument?
Yeah, and that's the argument that we did push so hard in the AAPC case, is saying, look, equal protection under the law says that if this group of individuals, firms, and clients are going to engage in core First Amendment protected speech, then to deny them loans that are otherwise available is a clear equal protection violation. However, the court and the appellate court sidestep that entire argument by saying, well, now wait, the PPP loans are in fact government subsidies for business activity, and government can choose what it does and does not subsidize. So that's sort of the problem that we had dealt with. And of course, Wisconsin, the court there saw it differently, but we did not have success in DC on that line of reasoning.
Interesting. Well, thank you very much, Steve. Charles, let me turn to you with a question or two here. Given Steve's experience and the ongoing exclusion of lobbyists from the PPP, What is your perspective on why the courts haven't taken the same position on SBA programs like the PPP that the court did in your case around having folks on boards and the like?
Well, I mean, to some extent, the reaction of the court, it depends on the judge that you have. And you know, as in my case with the ITECs and the government advisory committees, you know, we lost in the district court before a judge who thought that our case, as I said, was kind of insubstantial, and then won before 3 judges on the Court of Appeals who said, no, your case is very powerful. So to some extent, it's the luck of the draw. I think, you know, part of it also, as we've all been talking about, is that, you know, the practice of lobbying, even though it clearly is fully protected First Amendment activity, it is politically more difficult for courts to get behind, and courts to some extent are influenced by the general perception of the parties before them. So that unfortunately plays into it a little bit too. And the third, more substantial and legitimate, I think, concern is one that Steve touched on in his presentation on the question of what constitutes a subsidy from the government. There is no doubt that when the unconstitutional condition doctrine is invoked, if the government has a program that's generally available to everybody and doesn't involve giving them money as such, the doctrine comes into play. And so for government employment, other kinds of government programs that might involve spending of money, programs that don't involve spending money, certainly like ITACs, there's no question that the First Amendment applies. But the Supreme Court has had a very difficult time figuring out where to draw the line between subsidies. And the court has said several times very clearly, government is not obligated to subsidize the kinds of activity that it doesn't approve of, even though it's constitutionally protected. Can't discriminate against you for engaging in that activity, but doesn't have to subsidize it. Where do you draw that line between government employment, for example, which involves paying you a salary, and other kinds of programs that involve subsidies? And it's very hard to figure out exactly where to make that distinction. And I think that's really the key in the First Amendment context to these kinds of cases.
Interesting. So I guess given that, let me ask you to put your sort of hypothetical hat on here for a minute and give you a situation where, let's say, the lobbying profession decides they want to take this battle on to the SBA and win. How would you position that? Are there issues in your case that could be leveraged in the fight? And I guess maybe I think it's a little bit curious also that, you know, courts are allowing in some ways the SBA to disfavor businesses like lobbying firms, but others like newspapers and the like who are also engaged in speech aren't really held to that standard. I'd just be curious your thoughts on that.
Yeah, I think that's a very interesting point. And that clearly was something that appealed to the judges on the D.C. Circuit in our case. I mean, for example, the government had taken the position that basically the president can get to decide anybody that he wants to hear advice from in any context. It's his decision, no First Amendment principles involved there at all. And the judges, during the oral arguments in the D.C. Circuit, you know, were extremely skeptical about that. And they peppered the government's lawyer with questions like, well, if that's true, can the government discriminate against people because they vote? Can it discriminate against people because they are Latinos? I mean, can they make any kind of distinction if they want at all? And obviously the judges thought that was a kind of a preposterous argument. So I think that is the kind of maybe the way to play it in this context, that there are other entities that engage in very similar kinds of activities that are First Amendment protected, and nobody would think of denying them participation in a program because of that. And there is no doubt that lobbying should be treated in precisely the same way. So in the text of the Constitution, the right to petition the government for redress of grievances is treated just the same as the right to speech. So I think that the key is trying to get the court to focus on that principle, that this is all constitutionally First Amendment protected activity.
That's interesting. Thank you very much, Charles. Last but not least, got a question here for Gabe. Yeah, I think up until this point, we've been focused on some of the legal aspects and the cases around the PPP program. But as we talked about earlier, you know, Congress is in the throes of crafting their next response to the COVID-19 pandemic. And there has been quite a bit of conversation that's focused on the future of the PPP program. Dave, from your perspective, give us a little flavor of what the legislative state of play looks like. And this question here about how receptive have policymakers been to the arguments that the association community is more than just lobbying, and this is just one part of what associations offer.
Yeah, no, thanks, Tommy. I think that's an important question, and I do want to touch too on the question that was in the chat there regarding that aspect on the value that associations can add and what's going on beyond the lobbying activity that we do. Specific to PMI, I mean, absolutely, we offer certifications, a ton of workforce development stuff through training, through upskilling. These are all things that, especially in the current environment, when there's a lot of folks who find themselves unemployed or underemployed, that is critical to the recovery. So, and it's not just, you know, PMI that's kind of in that bucket. ASAE found that across all of the 501c6 associations, the average spend on lobbying is something like 5%. So, you know, speaking to some of the, you know, arithmetic concerns that Steve brought up earlier, that clearly doesn't rise to, you know, half of what we're doing. And oh, by the way, PMI, I think we're less than 1% even on our spend. So the perception that associations and 501c6s specifically are just you know, lobbying groups is not accurate. But to catch up a little bit on the play-by-play. The concerns about lobbying 501c6s and the PPP are still very much front and center. When the HEROES Act passed last month, there was some language in that bill that would have expanded access to PPP to all 501c organizations across the board, which was positive. But there was language also included in that bill that would exclude the salaries of lobbyists when calculating the loan amounts. You know, it's worth noting also that lobbying was the only worker profession that was called out specifically in the HEROES Act when it comes to PPP. So interesting nugget there. Now, on the Senate side, which is still working on its next COVID legislative response, there's several proposals floating around, a lot of discussion happening, some which both implicitly and explicitly create exclusions around lobbying. There's an example from a proposal from Ted Cruz. This is now the second draft that I think he's put forward. This one co-sponsored by Senators Rubio and Scott, which would allow 501c6 associations with less than 300 people to access the PPP, but also that would exclude, obviously, a variety of associations with large national or even international footprints like we've got at PMI. So I think they're also, they remain interested in making sure that lobbyists and lobbying activities are excluded. So still have a bit of a hill to climb there. But you know, we're fighting that fight, and I know others are too. So still a lot of ground to cover.
Thank you for that. We've got a couple questions and a couple of comments I think that are worth reading out and sharing with our panelists. One is from our friend Tom Fahey, who has noted that even in light of Charles's successful advocacy with regard to having lobbyists on various groups and boards and the like, that he points out that he has still been blocked by serving on some of these federal advisory commissions because agency officials continue to say that lobbyists are not permitted to serve. And so it looks like there may be a challenge there around some of those decisions being filtered down to the agencies. So a request, and Charles, I'll pass this along to you. If you would forward along the court's decision on this, we'll forward that out to everybody to take a look at it, because if they're experiencing this, that's very, very important, and we want to make sure that that they're not being discriminated against, particularly when the court has weighed in on the issue. Also, one from Todd White, who's talked about the importance of the profession having a more vociferous, unified position on this type of discrimination, rather than a splintered faction of legal groups who are fighting for footing on the issue. And I think that's also very, very important. Let me close down. We've got one more question here in the queue, and I guess this is for Steve, but Charles, I don't know, you may want to weigh in on this as well. But the question is, do you see lobbying firms deregistering some of their clients or some of their lobbyists, or pitching their clients differently to avoid that 50% threshold of funds in order to apply for these programs in the future? And I think that's probably an interesting question, given some of the concerns that have been expressed, within the public health community about the possibility of, further shutdowns in the winter and the like, and maybe, PPP sees its livelihood expanded far beyond its original threshold. Steve, I'd be curious to get your sense as to whether you think firms will be treating this differently or be registering as a result of the decision that was placed down in your case.
Yeah, I think just practically speaking, it would be tremendously difficult to structure a client engagement solely around the idea of making yourself eligible for SBA assistance, whether that's in the form of 7A loans or in the form of some kind of PPP program in the future. What I have seen a couple of firms do is create multiple business structures that do different types of work and often sort of put their lobbying activity that might trigger registration into just one of those entities. So, if it's done properly in a way that the affiliation rules don't get in your way, then it's possible that the other non-lobbying businesses within your structure would remain eligible for SBA assistance.
That's very, very interesting. Thank you. Taking a look at the time,
just to very quickly jump in. I don't know the practicalities, but in the government advisory committee context, we certainly did see a substantial number of people deregistering in order to qualify for service on advisory committees. So it is something that people can do and have done in the past in generally similar circumstances.
It's unfortunate when you think about, some of the broader societal goals around transparency and people wanting to, use sunlight as a disinfectant, that you have these decisions and these regulations that have been put forward that actually trigger the opposite, and that's unfortunate. But thankfully, we have you gentlemen on the case. And seeing no more questions in the queue, it looks like our time together is drawing to a close. So on behalf of Paul Miller, Nicole Smith from NILE, and the entire NILE Board of Directors, I want to thank everybody for being with us today. And a special thank you, especially to Charles, Dave, Steve, and Brad for sharing their perspectives and experiences with us this morning. I think you'll all agree that the conversation today was very insightful, and I think it gives us a lot to think about in the days and weeks ahead. If you did find today's conversation valuable, as Paul mentioned earlier, this is part of a broader series, and we'd like you to invite you to join NILE again on Monday, July 13th for another very timely conversation, this one on the need for greater diversity and inclusion within the lobbying profession. And as Paul also mentioned, we've got some upcoming sessions coming up on resume building and interview preparation in today's virtual hiring environment, featuring our friend, the great Ivan Adler, and some public policy certificate program courses on congressional procedures, media training, and more. So as we close down today, please take a look at lobbyinginstitute.com, the NILE website, and look at the upcoming events calendar. And with that, I want to thank everybody again for being with us today. Stay safe, be well, and everybody have a wonderful weekend. Take care. Thank you.
Thanks for having us.
Thank you.